Hi, our topic for today is the Anti-Money Laundering Act. What law governs the Anti-Money Laundering Act? Now, I have here a list of the Anti-Money Laundering Act penal laws that have been enacted. And if you can see, the penal law have underwent amendments many times already. So the latest one is Republic Act 11521, which was passed on January 29, 2021. The original one is Republic Act 9160. But actually, as far as the amendment is concerned, is because on additional covered institutions. So it's still very important to be familiar with all these penal laws because the subsequent amendment does not necessarily mean repeal of the older ones. But as far as my presentation is concerned, I already incorporated the necessary amendment. So what do we mean, or what have you understood by money laundering? It is actually a processing. It's the processing of criminal proceeds in order to disguise their illegal origin. In other words, from the illegal activities to which this money originated, it was actually, in layman's term, being laundered and then transacted or used in legal business so as to not to trace its illegal origin. Basically, laundering this money from illegal source to make it appear legal. So money from illegal activities is deposited in numerous legitimate accounts, making it difficult to trace so that the money can be used freely. So why do people launder money? So at least you can understand why or what is the logic behind the law. Basically, to use and enjoy the money with impunity. Remember that this money came from illegal sources, illegal origin. And because of its illegal source, you cannot just use them or benefit from them freely. That's why you need to clean them so that it would not be able to trace. We cannot trace as to its illegal origin. Without detection of the unlawful activity that produced the money, and without compromising or putting at risk the criminal proceeds as well as the criminal who wishes to benefit from said proceeds. So I have here stages of money laundering. So put it in your mind that you have there illegality of the source of the money. So what these offenders do is to place said money. You have there the initial placement or introduction of the illegal funds into the financial system, like banks and other financial institutions are usually used at this point for purposes of placement. Then after placement, to cover it more, you have there the act of or the stage of layering. It involves a series of financial transactions during which the dirty money is passed through a series of procedures, putting layer upon layer of persons and financial institutions into the laundering process. Example, from putting it in a bank, you make an electronic transfer of funds to another account, from that account to another account, and so on and so forth. Disguise the transfer as a payment for goods and services. It could be possible that from the bank, you use it to pay for shares of stock, any property, or you buy goods or services for that matter, or you bought a property. Then transfer the funds to Shell corporation. Then thereafter, let's say that, example, you already bought some property from that illegal source. You integrate it back. The money is once again made available to the criminal with the occupational and geographic origin obscured and concealed. Example, remember that you made money transfer already for a particular fund from one account to another account or to another person, from another person, then that person maybe give back to you the money. So, or the property came back to your possession at the end of the long layering process. So the laundered funds are now integrated back into the legitimate economy through the purchase of properties, businesses, and other investments. Now, please take notice on the so-called covered institutions. Covered institutions. So when we say covered institutions, these are institutions to where the provision and to where the powers of AMLA can be made effective. These are the institution under the supervision, or let's say control, or within the authority, within the scope of the law. So what are the covered institutions? Banks, non-banks, quasi-banks, trust entities, and other institutions and their subsidiaries and affiliates supervised or regulated by the BSP or the Bangko Sentral ng Pilipinas. So all of them are under the covered institutions. What else? Insurance companies and other institutions supervised and regulated by the Insurance Commission. And you also have there security dealers, brokers, salesmen, investment houses, and other similar managing securities or rendering services, consultancy, mutual funds, closed and investment companies, common trust funds, pre-need companies, and other similar entities, foreign exchange corporations, money changers, money payment or money remittances, as well as transfer companies and other similar entities. And entities administering or otherwise dealing in currency, commodities, or financial derivatives based thereon valuable objects, cash substitutes, and other similar monetary instruments or property that are supervised and regulated by the Securities and Exchange Commission. And this is where the amendment comes in because the covered institutions have been expanded. So what else? You have their jewelry dealers of precious stones or businesses engage in the trade of precious metals for transactions in excess of 1 million pesos. Jewelry dealers in precious stones or business in precious stones for transactions in excess of 1 million pesos. You also have their company service providers. And then a director or corporate secretary of a company, partner of a partnership, or similar position in relation to other juridical persons. We also have their registered office, business address or accommodation, correspondence or administrative address for a company, partnership, and other legal person or arrangement, or acting as a nominee, shareholder, or other person that is included in the covered institutions. Persons who provide the following services are as well covered: managing a client money, securities, or other asset, management of bank, savings, or securities account, organization of contributions for the creation, operation, or management of companies, creation, operation, or management of juridical persons, arrangements, and buying and selling business entities. Now take note that notwithstanding the foregoing, the term covered persons shall also include lawyers and accountants acting as independent legal professionals in relation to information concerning their clients or where disclosure of information would compromise client confidences or the attorney-client relationship, provided that these lawyers and accountants are authorized to practice in the Philippines and shall continue to be subject to the provisions of the respective codes of conduct and or professional responsibility or any of its amendments. In other words, we enumerated to be part of the included institution, you have their covered persons. So you have there from 4, 5, 6, 7, and then as to lawyers and accountants, because they have their the so-called confidentiality with respect to their transaction with their clients. So you have there the lawyer-client or the accountant-client relationship. They are actually excluded, okay? Excluded from the term covered persons, that if their clients have these transactions falling within the enumeration, like the transaction on, let's say, precious stones, and their client told them, and in fact they helped in the processing or facilitating the transaction involving 2 million. So they are not covered because the losses shall exclude, because they are bound by their code of professional responsibility. You also have their casinos, okay, including internet and ship-based casinos. And then the casino refers to a business authorized by the appropriate government agency to engage in gaming operations like the internet-based casinos. You also have there the ship-based casino. If the casino is in a ship or a vessel. It would also include that we are having now here the covered transaction. So covered institution, from covered person, you have here covered transaction. The casino cash transaction refers to transactions involving the receipt of cash by a casino paid by or on behalf of a customer, or transactions involving the payout of cash by a casino to a customer or to any person in his or her behalf. You also have their gaming operations like the Pogo. So those transactions there are actually included. Real estate developers and brokers, offshore gaming operations. So these are all covered transaction or institution or person under AMLA. So since we mentioned in passing covered transaction, what then are covered transactions under the law? Because initially we have their covered institutions. That's why we enumerated those under the supervision and regulation by the BSP, Insurance Commission, the Securities and Exchange Commission, and the other enumeration. We also have here transactions, covered transactions. Is a transaction in cash or other equivalent monetary instrument involving total amount in excess of 500,000 pesos within one banking day for covered persons under 3A, paragraph 8, a single casino cash transaction involving an amount in excess of 5 million pesos or its equivalent in any other currency. So for ordinary persons like us, that's why if you go to the bank and you want to deposit or withdraw in the amount of 500,000 pesos in one banking day, oops, you cannot do that with just facility because that is a covered transaction. You also have their covered persons under Section 3A, Paragraph 9, involving a single cash transaction involving an amount in excess of 7,500,000 pesos or its equivalent in any other currency. So, from those definitions, we also have here the so-called suspicious transactions. By the term itself, suspicious, the transaction itself is unknown or cannot be traced with certainty. Hence, regardless of the amounts involved, that suspicious transaction has to be reported to the AMLA. When shall there be, or what constitutes a suspicious transaction? When there is no underlying legal or trade obligation, purpose, or economic justification. So in other words, because it would be possible that you are a VIP or a valued client for a particular bank, but if you are not their valued client, meaning to say that it is really hard to trace even your means. So where did you get this amount of money? Because the client is not properly identified or the amount involved is not commensurate with the business or financial capacity of the client, even if did not reach to that amount as the minimum to be included as covered transaction, that is considered to be suspicious transaction, which requires on the part of the covered institution and covered person to report the same to the AMLA. Okay, that is regardless of the amount involved. So what else would justify or would constitute that the transaction is suspicious? There, taking into account all known circumstances, it may be perceived that the client's transaction is structured in order to avoid being the subject of reporting requirements under the Act. Now, what do we mean by this? Now, remember, you may be a valued client for a particular bank, and to circumvent the reportorial requirements, di ba, in one banking day, you have their 500,000 pesos in one banking day. It could be possible that today you deposited 100,000, the next day 100,000, or next week another 100,000, meaning to say these transactions of a particular client is being structured in such a way to do away with the reporting requirements. Actually, that act of yours is considered to be suspicious transaction. It may not reach 500,000 pesos. Hence, there is no 500,000 in a banking day where the bank may not report you to the AMLA as required, but then the bank was able to see a structure or a pattern to all your transactions, despite the fact that it does not include a 500,000 peso in one banking day. So that is structured, okay? Perceive that the client's transaction is structured. Any circumstance relating to the transaction which is observed to deviate from the profile of the client and or the client's past transaction with the covered person. So it could be possible that this covered person has been dealing with you previously, but then he discovered or observed a deviation of the usual business transaction that you have with this particular client. So there is deviation. And then the transaction is in any way related to an unlawful activity or offense under this act that is about to be or is being or has been committed, or any transaction that is similar or analogous to any of the foregoing. So anything done, okay, anything done that would circumvent the law as far as reportorial or the record keeping requirement required by the AMLA, that constitutes suspicious transaction. The covered person or the covered institution shall also report you to the AMLA. So to be specific as to the other reportorial transaction, because we're only mentioning about the 500,000 pesos in one banking day. So to reiterate, you have there the jewelry dealers. So if the transaction with these precious metals is in excess of 1 million, precious stones in excess of 1 million, if you bought there a property in excess of 500,000, so the LRA and the Register of Deeds are also required to report the same to the AMLA. You have there a casino single transaction in excess of 5 million. You also have the real estate brokers and dealers in a single transaction in excess of 7,500,000. So you have there the definition of precious metals and precious stones. So just go over them. So what is the procedure? As far as reporting is concerned, there is a requirement on reporting as far as covered transaction is concerned and suspicious transaction is concerned by the covered institution and covered persons to the AMLC. So the covered persons which we have enumerated earlier, including the covered institution, shall report to the AMLC all covered transactions and suspicious transactions. Who are the covered persons? So the persons referred to here, those banks and others governed by the Bangko Sentral. You also have there the entities regulated, supervised by the Insurance Commission. You also have there other entities governed by the Securities and Exchange Commission, and all the rest of the enumeration. They are the covered institution, covered person. To cite as an example, you have there the dealers. What shall they report? Covered transaction. So the example, the most common that we have is the 500,000 peso amount in one banking day. And regardless of the amount, if the same is considered to be suspicious because you cannot identify the identity even on the client, so they have to report this to the Anti-Money Laundering Council under the AMLA law. So when reporting covered or suspicious transaction to the AMLC, covered persons and their offices and employees shall not be deemed to have violated RA 1405 as amended by 6426, as amended by 8791 and other similar laws, because they are actually immune from possible suit. It is an exception. 1405, that is the bank secrecy. So since they are required under the AMLA law, they are not covered by the provisions under RA 1405 as amended, RA 6426 as amended, and RA 8791 and other similar laws. Okay, let's go further on the illegal activity enumerated under the amendment, specifically under RA 10365. What are the illegal activity being referred to here, to which might be the source, illegal source of the money subject under the anti-money laundering? It refers to any act or omission or series or combination thereof involving or having direct relation to the following. In other words, this illegal activity as enumerated, we call them as predicate crimes. Okay, predicate crimes to which this money subject of the money laundering have originated. And what are these illegal activities referred to? Kidnapping for ransom, violations under RA 9165, violation under RA 3019 or the Anti-Graft and Corrupt Practices Act, money from plunder, money from robbery and extortion, money from wetting and martial, money from piracy, money from qualified theft, money from swindling, money or proceeds from smuggling, and violations under RA 8792. You also have here proceeds from hijacking, terrorism,
What's that?
bribery,
What's that?
frauds, malversation, forgeries, violation under the Anti-Trafficking in Persons Act, violation under the Revised Forestry Code, violations under the Fisheries Code. You also have their violations under the Philippine Mining Act, violations under RA 9147, violation under the National Caves and Caves Resources Management Protection Act. You also have their proceeds from carnapping, proceeds from the illegal and unlawful possession of firearms, ammunition, or explosives, violation under the anti-fencing, violation under the RA 8042, violation under the Intellectual Property Code. You also have their proceeds from violation under the Anti-Photo and Video Voyeurism, violation under Anti-Child Pornography Act, even violation under 7610, or you have their proceeds from violation under RA 8799. You also have their Republic Act 10697, violation under the NIRC, and then felonies and offense of similar nature that are punishable under penal laws of other country. So we call them as predicate crimes. So with the knowledge that you have earlier, so what then is money laundering? So Section 4 defines money laundering as committed by any person who, knowing that any monetary instrument or property represents, involves, or relates to the proceeds of any unlawful activity, transacts said monetary instrument or property, converts, transfers, disposes of, moves, acquires, possesses, or uses said monetary instrument or property, conceals or disguises the true nature, source, location, disposition, movement, or ownership of all rights with respect to said monetary instrument or property. Or if the person attempts or conspires to commit money laundering, he abets aids or assists in or counsels the commission of money laundering, or perform or fails to perform any act as a result which he facilitates the offense of money laundering. Money laundering is as well committed by any person covered by any covered person who, knowing that a covered or suspicious transaction is required under this act to be reported, but he fails to do so, he is actually liable as well for money laundering for his failure to report. Now, question. So you have their knowledge, because a requirement of the offender in AMLA is that the person knows, he has knowledge of the illegality of the money or property to be a proceed from this illegal or unlawful activity. So when do we, or how do we know that the person has knowledge so that he is liable for AMLA? Now, this is a US case, US versus Rudisill. Knowledge may be established by direct evidence or inferred from the attendant circumstances. Plainly, a jury could reasonably infer from these actions on the part of Tim that he had knowledge of the conspiracies and knowingly associated himself with them and furthered them and sought to avoid detection of them. So this is actually a case, I think he is the father-in-law of the person who actually do the actual overt act of all this illegal activity. He knows, he have seen all this voluminous money. So he cannot say that he has no knowledge because he have seen this on the overt act of his son-in-law, and he saw the many voluminous or let's say money in their possession. So he has knowledge. Now, we also have the so-called willful blindness doctrine. Now, the accused of AMLA may invoke this as a defense. When we say willful blindness doctrine, you already saw it, and that you continue to deny. You turned a blind eye of what you have seen. That's why it's called willful blindness doctrine. A state of deliberate ignorance of a certain fact, impute knowledge to an accused whose suspicion is aroused at the point where he or she sees the need for further inquiries, but deliberately chooses not to make those inquiries. That's why in the case of Tim, it was already before him, and yet he refuses to make any inquiry. What are this money doing here? Where does this come from? So we call that as willful blindness, that he turned a blind eye of this circumstance which could have aroused his suspicion, which requires that he would be doing some further inquiries, but deliberately chooses not to make those inquiries. So, what can we say about it? It's untenable. Who has jurisdiction over money laundering cases? So you have there the RTC shall have jurisdiction to try all those cases on money laundering. Those committed by public officers and private persons who are in conspiracy with such public officers shall be under the jurisdiction of the Sandigan Bayan. So they have concurrent jurisdiction. So please take note as well on who are under the jurisdiction of the Sandigan Bayan. For public officers, you have there general rule at least salary grade 27. So if not, the jurisdiction is with the RTC. Now, next question. Considering that the source of the money subject in money laundering came from the unlawful activity, is there a need that we have to prove first the predicate crime or the unlawful activity before we can prosecute the accused for AMLA? Now you have there section 6. It says here that any person may be charged with and convicted of both the offense of money laundering and the unlawful activity as herein defined, because the elements are different. So if the predicate crime or the unlawful activity is robbery, you have to prove all the elements of robbery. Whereas the AMLA there is you have to prove the element under AMLA that the money subject of the laundering is a proceed from robbery. Now take note, the prosecution of any offense or violation under this act shall proceed independently of any proceeding relating to the unlawful activity. They may proceed, they shall proceed, shall is even used, shall proceed independently. But my question here is, what if the accused was acquitted in the predicate crimes or in the unlawful activity? Meaning to say, while they may be charged under both, and the proceedings can proceed independently, but his conviction under AMLA would be dependent on his conviction on the unlawful activity. Because what if he was acquitted on the unlawful activity or the predicate crimes? So we cannot say that the money subject in the AMLA is a proceed of the unlawful activity if he was acquitted. But again, that would depend upon the reason of his acquittal. Okay? Dependent on the outcome of the unlawful activity, because even if he is acquitted, it could be that the prosecution failed to prove his guilt beyond reasonable doubt, but they were able to establish that indeed this money was a proceed of the robbery, then that would still be possible. So do not jump into conclusion right away. Again, he may be charged under both. The proceeding may proceed independently, but as to the outcome, I think AMLA has to wait for the outcome here of the unlawful activity, because we have to connect that the money subject in the AMLA are really proceeds from this unlawful activity. So you have there the Anti-Money Laundering Council. So basically, this is the council tasked for the implementation of the provision of the Anti-Money Laundering Act. Basically, their function is to investigate suspicious transactions as well as covered transactions. They also have there the mandate on issuing orders. They also have there the mandate of instituting civil forfeiture, filing of complaints, investigate suspicious uncovered transactions. They also have may apply for freeze order before the CA and such other functions necessary for the implementation of the provision of the AMLA. So further, they also have there the function on inquiry to the LRA. In fact, LRA and the Register of Deeds has to submit report on all their real estate transaction involving the amount of 500,000. That's why I mentioned earlier on the reportorial requirement of these covered persons or covered institutions with respect to covered transaction and suspicious transaction. So do not forget that the covered person, covered institution is required to submit a report, or you have there the reportorial requirement as far as the AMLC is concerned with respect to covered transaction and suspicious transaction. So you have there also their function to conduct investigation. They have as well the duty to preserve assets pursuant to the freeze order that they had after application with the CA. Now take note that I mentioned earlier that the covered person, covered institution have that reportorial responsibility to the AMLC with respect to covered transaction and suspicious transaction. Now take note that that report is considered to be confidential, okay? Confidential. Now for purposes of implementing properly the provision of the AMLA, there are actually preventive measures that are required by AMLA for purposes of preventing money laundering. So they have their customer identification requirement and record keeping. So as far as the covered institution and covered persons are concerned, they are required to maintain a system of verifying the true identity of their customer. So you have their customer identification. And then aside from that customer identification, you have there the reporting of covered transaction. When will they report it? Within 5 working days, and that would include the reporting of the suspicious transaction. General rule, that is the 5 working days. So again, exempted lawyers and accountants acting as independent legal professionals. So they are not required to report covered and suspicious transaction. Now, if this reporting on the part of discovered person or institutions are concerned, they are made in the regular performance of his duties and in good faith, even if later on it turned out to be legal, not illegal, what would be the effect as far as that person who made the report? He shall be immune. He cannot be sued. In the first place, it was in the regular performance of duty and it was done in good faith. In other words, if it was done with malice, not in good faith, then that would be another story, because that would subject the covered person to be made criminally liable. Now, Section 10 actually provides the authority to freeze as far as AMLC is concerned, but they have to apply first for that order from the Court of Appeals. So just go over Section 10. Now, if they had successfully obtained a freeze order and no case was filed thereafter, so the freeze order shall be deemed ipso facto lifted after the period of 6 months. Now, what would be included in the freeze order? It shall be limited only to the amount of cash or monetary instrument or value of property that the court finds there is probable cause to be considered them as proceeds of a predicate offense or the unlawful activity. Now, take note, as far as freeze order is concerned, no court shall issue a TRO or a writ of injunction against any freeze order except Supreme Court. Now, take note, the jurisdiction may be lodged in the RTC. So, no other RTC should issue a TRO or injunction as far as the freeze order is concerned, even the CA. It's only the Supreme Court. Here. So this is still on the freeze order, so just go over them. Now, take note that the AMLC also has this authority to inquire into bank deposits, RA as amended, as provided under RA 10167, without violating the right of the client depositor or the accused in under the AMLA provision on the bank secrecy of bank deposits under RA 1405 as amended. So the AMLC can inquire into the bank deposit of the person after application therein, still before the CA, to inquire into the bank deposit. Okay, still CA. As far as the forfeiture function of the AMLC, either they will institute a civil forfeiture, claim on forfeited assets, or the payment in lieu of forfeiture. And as far as the forfeiture proceeding is concerned, no court shall issue again TRO or a writ of injunction against any provisional asset preservation order or asset preservation except CA or the Supreme Court. But as to the freeze order, only the Supreme Court. But here, you can apply before the CA as far as the forfeiture of the proceeds are concerned. So you may file a TRO or an injunction before the CA or Supreme Court if you are the aggrieved party on the forfeiture proceeding. Okay, so let's proceed with the penalties. If the act of the accused falls under 4A, B, C, and D, the penalty shall be 7 to 14 years and a fine not to exceed 3 million, but not more than twice the value of the monetary instrument or property. If the accused is charged under 4E and F, 4 years to 7 years and a fine of not less than 1,500,000 but not more than 3 million. If the accused is charged under the last paragraph of section 4, so that would be 6 months to 4 years or a fine not to exceed 100,000 pesos, but not more than 500,000 pesos or both. So those are the penalties. As to the failure to keep records, 6 months to 1 year or a fine of not less than 100,000, but not more than 500,000 or both. As to malicious reporting, remember the person who made a report in the regular performance and in good faith, immune. But as to malicious reporting, 6 months to 4 years of imprisonment and a fine of not less than 100 but not more than 500,000 at the discretion of the court, that the offender is not entitled to avail the benefits of the probation law, despite the fact that the penalty imposable to him is probationable. So this is an express prohibition to avail of the provisions under the probation law. If the offender is a corporation or a juridical person, so who can be made liable? Those who participated or allowed by their, or the persons who allowed by their gross negligence the commission of the crime in violation of the AMLA. And any public official or employee who is called upon to testify and refuses to do so, fails to testify, the same penalty shall be imposed upon him. Breach of information security and confidentiality, the penalty shall be 3 to 8 years and a fine of not less than 500,000 to not more than 1 million pesos. Now, if the breach is committed by a juridical person, then that would be the penalty. How about administrative sanction? That would be different from that of the criminal penalties. The one that we mentioned earlier are criminal penalties. So without prejudice to the filing of criminal charges, so meaning to say the imposition of administrative sanctions are as well allowed without violating the right of the accused to double jeopardy. Now, during the proceeding, Section 20 provides that the BIR shall not participate, or the AMLC shall allow in any proceeding before the BIR. Okay, so they have different jurisdiction. So as far as violation under the NIRC as the predicate crime, that is within the jurisdiction of the BIR. And then AMLC as far as the prosecution of the accused for violating the AMLA. So possible question on AMLA, what are the institutions covered? So we enumerated earlier on the covered institutions. And who are the covered persons? Then thereafter, you must learn or you must master what are the transactions covered, so that the covered persons or the covered institutions is mandated to make a report to the AMLC. And then what constitutes or when shall there be suspicious transaction? And with that, what is money laundering and what are considered to be unlawful activity? And from this unlawful activity, you have there the proceeds subject in money laundering. So those are the pertinent provisions under the Anti-Money Laundering Act. Thank you and God bless you all.